Members, I call to order the meeting of the Bills Committee on Advance Decision on Life-Sustaining Treatment Bill. There is a quorum, and it is the appointed time. Item 1 on the agenda, election of Deputy Chairman. Does any member have any views on Deputy Chairmanship? We do need a Deputy Chairman because we will spend a considerable amount of time on debating this bill. Now, by the end of the nomination period, the Secretariat has received only one valid nomination for Deputy Chairmanship. That is Ms. Connie Lam, nominated by Mr. Bill Tang and seconded by Ms. Doreen Kong. Now, if there are no views to the contrary, we congratulate Ms. Connie Lam to take the Deputy Chairmanship of this committee. Now, I will invite the administration to come into the room. I remind members, I know you have a lot of questions. The bill is lengthy and the paper is very long, so please only press the button after the presentation of the administration. Listen to what they have to say and then press the button when I invite you to do so. I welcome the Undersecretary for Health and her team. Now, please brief us on the paper and the bill. Thank you, Chair. Good morning. The Advance Decision on Life-Sustaining Treatments Bill seeks to offer a good end-of-life service to terminally ill residents, people and their families. Now, the Advanced Medical Directives and Do Not Attempt Cardiopulmonary Resuscitation orders, or DNA CPR orders, are important measures to enhance the end-of-life living quality of patients. Now, here are the details of the bill. In 2019, concerning the end-of-life care in Hong Kong, we have consulted the public. In 2020, we have published the findings of the consultation reports. The report shows that our direction was supported by the general public to implement the recommendations in relation to the legislative framework on AMDs, as well as facilitate dying in place for patients. As mentioned in the report, we have consulted the Health Services Panel last year. Our proposals were supported by members. The proposals of the bills include providing for the legislative frameworks for AMDs and DNA CPR orders, and to strengthen the safeguards attached. 2, providing protection to medical professionals as well as rescuers, including lay rescuers, in relation to AMDs and DNA CPR orders. 3, we will amend the Fire Services Ordinance Cap 95 and the Mental Health Ordinance Cap 136 to remove conflicts between relevant provisions in the ordinances and the legislative frameworks for AMDs and DNA CPR orders. For AMDs, they will be implemented in model forms, and they are usually in written forms, so that when the AMD makers, when they are mentally capable of deciding on a life-sustaining treatment, they would decide not to be subjected to any life-sustaining treatment when they are mentally incapacitated. To facilitate the implementation of AMDs outside a hospital setting, a registered medical personnel, or RMP, can facilitate the AMD maker to make a DNA CPR order, so that under the specified circumstances, CPR should not be performed on the patient. We reiterate that the that AMDs and euthanasia are two distinct concepts. For the instructions made in the AMD, it is for withdrawing or withholding life-sustaining treatment in specified situations. AMD makers cannot refuse basic and palliative care or request the administration or prescription of a substance to end the life through AMDs. The making of AMDs would be premised on the principle of cautious making and easy revoking. This is very important. In cautious making, we mean that the AMD makers must go through a vigorous process in considering whether he or she would take out the AMD. By easy revoking, we would facilitate easy revocation of the AMD should the patient change his or her mind. In the making process, there must be not less than 2 witnesses who fulfill certain requirements. One of these witnesses must be a RMP, who should be satisfied that the maker is mentally capable of deciding on a life-sustaining treatment at the time when the maker signs on the AMD. And 2, that he or she has been informed of the nature of the AMD, as well as the effect of following each of the instructions in the AMD on the maker himself. On easy revoking, as long as the AMD maker is mentally capable of deciding on a life-sustaining treatment at the time, he or she can revoke the AMD at any time by verbal or written means or by destroying the AMD. The scanned copy of an AMD can be stored in a specified electronic system as a validating proof. Besides digital storage of AMD, we are also actively studying the full electronic route for making and storing AMDs. To ensure that the provisions can be put in place when all the relevant technical conditions are met. Now, in terms of rescue, rescuers would follow the principle of if in doubt, save life first, because the rescue process is a decision has to be made in split second. Now, when specified conditions are met, rescuers and medical personnel will be exempted from liability for subjecting or not subjecting the patients to CPR. For example, when there is an AMD or a DNA CPR order in place, when rescuers perform CPR on the patient, if the rescuer is not aware of the existence of the DNA CPR or that a RMP has issued a DNA CPR, or if that's the rescuers is of genuine and honest belief that the instructions are not valid and applicable, then they will not incur any civil or criminal liability for performing CPR. On the other hand, if the rescuer genuinely believes that the instructions are valid and applicable and they do not subject the patients in arrest for CPR, they will not incur any legal liabilities. The reasonableness of the actions taken by rescuers and medical personnel will be assessed on a case-by-case basis. For example, lack of information at the scene and also the constraints of time will be taken into consideration. Now, we propose setting aside sufficient time after the introduction of the bill for the relevant medical institutions and organizations to update their protocols, records, and systems and provide training to their staff. We will also roll out a public education campaign in relation to end-of-life care as well as dying in place. We will also promote the new legislative framework to CPR training bodies. We will also enhance training for fire and ambulance personnel. Now, the preliminary plan is that the provisions will take effect only 1.5 years after the passage of the bill. Thank you. We will first scrutinize the policy issues of the bill So if you have any questions on policy matters, please press the button. When you speak, please state your positions on whether we need to invite submissions from the public. In any event, all the submissions will be passed on to the administration for a consolidated reply. There are 8 members who have pressed the button, so I will give you each 5 minutes. They are Dr. Teck Chi Yuen, Bill Tang, Chen Pui Leung, Reverend Peter Kuhn, Lee Chen Keung, Ms. Connie Lam, Carmen Khan, and Mr. Dennis Leung. Dr. Teck Chi Yuen. Thank you, Chair. On whether we should invite bodies to join the discussion, I think that is necessary. In the social welfare sector, we have been calling the governments to do this for many years. But this is not easy. Many people, especially the elderly, are averted to the idea of a discussion about death. So I think it would be meaningful if we invite the public to join the discussion. In your explanation to the public, the administration should focus on the benefits of this bill on the patients and their families. Now, I think you have to educate the frontline medical officers as well. That is necessary. Well, but what about the families? Some family members would be surprised if they learn that CPRs would not be performed on their loved ones if there is an order. Now, there are lots of movies that showing that even if you lost unconsciousness, then after performing some mouth-to-mouth resuscitation, the patient would be revived miraculously, or even a drop of tear would do the miracle. So you have to educate the public on the benefits of the bill. Now, I understand that there are only 5,000 voluntary signatories to AMDs or DNA CPR orders. Now, with a legislative framework, it would facilitate the process a bit, but whether it would encourage the public to make these orders, well, I have doubts. Now, you say you will set aside 18 months for the education campaign, so I hope you will involve the social welfare sector, the medical sector, and even the education sector for maximum results. Now, I think an electronic system is required, and an electronic route to making AMDs is required. Now, you may misplace the paper form of AMDs, so I think digital version is necessary. Same applies to the card for the elderly people. You can simply tap the card, and then the information can be retrieved. You have to understand that there are lots of conflicts in the family concerning this matter. Now, with a better training for a medical social worker, we can facilitate understanding by the family members. Thank you.
Undersecretary, thank you. I thank Dr. Teck for his comments. Great ideas. We will consider those. On publicity. Today we are discussing a bill, so we don't go into detail about the benefits, but when it comes to publicity, we will do the publicity along with life and death education. We will explain to people why we are pursuing this bill. It's about respect for patients' wishes. This bill is not there to encourage more people to sign advanced medical directives. The goal is to give patients more options. There are legal ambiguities. These ambiguities are holding patients back. They're creating problems for healthcare professionals. So we will do more publicity. The bill is there to help us overcome certain hurdles. Now, on going electronic, we have two phases in mind. So we can have an electronic platform to store a paper-based AMD. It's fine if you don't have it with you. You can just let the healthcare worker know where to find it on a cloud platform. We are exploring the idea of an electronic platform. E-health is one option. We have more than 5 million people already on e-health, so that may be a convenient option. In the long run, we do want to go electronic so that the AMD can be made electronically instead of on paper. So that's our long-term plan. Now, family disputes. It's important to get family members involved in making AMDs, especially in a Chinese society. That's why we require two witnesses, one being a doctor. Maybe 6 or 9 months beforehand, the doctors have to talk to the family members of a patient. The doctors have to inform the patient and their family the effect of the AMD. This needs to be a cautious process. So engaging the family members is crucial. This process can also help reduce disputes. A reminder to Dr. Tick, you are not a member of this Bills Committee, but I welcome your participation. After all, this bill touches on many sectors. The comment from Dr. Tick is something I believe the government will also consider. Mr. Bill Tang. This bill is a life and death matter. Professionals are involved. So we should invite submissions from professionals so that we don't miss anything. I also thank the Health Bureau for an in-depth exchange with us yesterday so that we now have a picture of the bill. Over the past years, the hospital authority adopted measures administratively and medically on AMDs. We should respect a patient's wishes. But the patient may have something different in mind from their family members. The patient may want to refuse treatment, but the family members may want to go on. In other cases, the family may want to sustain the treatment or let go while the patient disagrees. Do we have disputes in the past? Were there cases that went to the court? One side wants treatment, the other side didn't want it. Have we seen such cases, landmark cases? Now, my second point, it's about the bill. There are two forms. The immediate family members cannot sign the forms because of potential conflicts of interest. After all, family members may have a beneficial interest in a patient's estate. So, one possible scenario is that a patient makes an AMD without the knowledge of their immediate family. After all, the witness or the one signing the form cannot be someone with beneficial interest in the estate. What if this patient deliberately withholds the information from their immediate family members? So the family members are left in the dark, and then the medical carers are in a bind. What to do? Now, my third point. Will we create the impression that this bill has to do with euthanasia? Of course, this bill has nothing to do with euthanasia, but how can we explain to the public clearly that this bill has nothing to do with euthanasia and it does not encourage euthanasia? What are some ways we can explain this clearly and convey this message clearly to the public? Thank you. I will invite my colleague, Dr. Doris Chair, to give us more details about avoiding disputes. But before I give the floor to Dr. Jie, I want to make one comment. Indeed, when a family member has a potential conflict of interest or beneficial interest in a state, they cannot be the witness, but they can be part of the discussion. So the doctor explains an AMD to the patient. The family members can be part of that discussion. The discussion may happen at an outpatient setting. The doctor meets with the family members. At the end of the day, it's about respecting the patient's wishes. Dr. Jie can tell us more in a moment. Now, euthanasia. This has to do with life and death education and public education. We make it clear that AMDs have utterly nothing to do with euthanasia. And there are different kinds of euthanasia. Assisted suicide is one form of euthanasia, and we have to make this point very clear in our publicity. We need to make sure the public is aware that euthanasia has nothing to do with AMDs. And the Chinese term "onnoxei" isn't a very good rendition of euthanasia. We have to make it clear. It's a way to help a patient die. But AMDs are a different concept. So when the patient is no longer mentally capable, we execute an instruction made by the patient while the patient was still mentally capable. I now give the floor to Dr. Doris Jie to elaborate on the other points. Thank you. Before a patient signs an AMD, the patient goes through advanced care planning. The HA invites the patient's family members to be part of the process. At this point, the doctor has to do something. Our Chinese are not accustomed to talk about death. So here in this process, we try to get the patient to let their family members know their wish. So signing an AMD may take more than one discussion. The palliative care team has its work to do. After the doctor talks to the patient, the nurse visits the family, and the nurse may have to talk to the family again. So we need to make sure the patient is fully informed and the family members agree, and only then the doctor signs off the document. In the Chinese society, we are well aware of the importance of the family's involvement, and the family members need to be fully aware of the patient's wish. When the end of life comes, the decision has to be made, and that's a painful moment. And this will be very tough for the family members. That's why we need advanced planning, and we have to let the patient know beforehand. That some patients may say, we will make the decision when the time comes, or someone else can decide for me. We have to explain to the patient that it's best to have the patient express their wish when the patient can still do it. If the patient wants to refuse cardiopulmonary resuscitation, we explain to the patient that at that moment the patient cannot convey the wish because at that point the patient is unconscious. Blood transfusion, for example, is a different case because at that point the patient is still conscious. But when someone is in cardio arrest, the patient cannot let us know whether they want the resuscitation at that point. So we explain all these matters clearly to the patient and the family members. Now, on the clinical side of things, whether there will be a conflict. When there's a conflict, we don't sign off. We go through this process, the family members come to a consensus. It's about the patient's wish. Family members should also respect the patient's wish. I don't have in mind any case where you have a conflict and we cannot sign. There were patients who decided to revoke their AMDs afterwards. And the family members agreed because the family members respected the patient's wishes. Thank you. Next, Mr. Chen Pui-Leung. AMDs are already in place. It's just that we don't have a legal basis for it. It's just that AMDs have been running on the basis of common law only so far. The bill is here to clarify the liability for healthcare professionals, and I think this bill is helpful. But there are some things I want to find out about this bill. Registered medical practitioners or RMPs will play a key role in the process. Specialists may be involved. Chinese medical practitioners may also be involved. Can Chinese medicine practitioners also be part of this AMD process? A CMP may also be a witness of an AMD. What will be the role of Chinese medicine practitioners in AMDs? That's my first question. Second, the forms. The form looks complicated. It's several pages long. Some forms are for adults, others for minors or for people who cannot care for themselves. In the forms, there are boxes to check. But then, in other fields, the patient has to fill in information. And the patient has to specify the diseases such that when those diseases kick in, they want to refuse treatment. So can we simplify those forms and make the forms clearer? Now, I think it's important to go electronic with the forms. The government just told us that's their direction in the future. They are considering putting the forms or AMDs on e-health. That's a good direction. Now, we have a model form for the AMD. But the AMD maker can also make their AMD in other forms. Why not just stick to this model form? If patients can use other forms that meet the requirements, wouldn't that involve more work in approval or vetting? And as other members indicated, let's not underestimate the problems that may come up from easy revoking. A patient may have made an AMD. The patient wants to refuse treatment, but the family members may want to insist on treatment. The revoking can be done orally or in writing. The family members may say the patient whispered to the family members that they want to revoke the AMD. So that's a case of oral revocation. Should the healthcare worker save the patient in that case? We need to anticipate such possible scenarios in greater detail. Otherwise, more disputes may arise in the future. Those are my three questions. Undersecretary. Thank you. On the question about Chinese medicine practitioners, my colleague, Mr. Eddie Lee, can tell us more in a moment. Now, a comment on the forms. Mr. Chen made a good point. We propose a model form for the AMD. The patient has to set out in writing the instructions, and that will be good enough for instructions in an AMD. But the patient also needs two witnesses, and one witness has to be an RMP. The RMP is there can help make sure the written instructions are clear. As Dr. Doris Jie just said, it's a process that involves discussions and engagement. Everyone involved has to be clear about what the instructions are when the instructions kick in. So that's a way to minimize ambiguities. We want to stress that AMDs are not something that will happen after a one-off interaction. When the end of life comes near, the process starts. The AMD is made when the parties are aware of the patient's wishes. Now, on oral revocation, one witness is needed. Would this be too low a threshold? We discussed this. The doctor is there. The doctor has met with the patient and the family members repeatedly. The doctor will have to make a professional judgment. When the family member says the patient has orally revoked the AMD, the doctor has to judge whether that's valid. The doctor has spent time with the patient. Say the patient wants to keep the AMD, but the family members say the patient wants to revoke the AMD. That's when the doctor has to make a professional judgment. The doctor has to be reasonably and honestly satisfied the AMD is revoked. So the doctor is there to make a professional judgment, and then the doctor is the gatekeeper. So it's not like the AMD can be revoked simply when the family member says so. So the doctor's input matters. Now, on Chinese medicine practitioners, I will invite Mr. Li to tell us more.
Chair, on the role to be played by Chinese medicine practitioners in the legal framework. In terms of the witnesses to the making of an AMD, the RMP should be a registered Western medicine practitioner. Many of the instructions to be included on the AMDs are in the realm of Western medicine. Now, the RMP as a witness has a role to play. He or she is not just a witness. They have the duty to explain to the AMD maker the nature of the AMD as well as the effects of the instructions on them. The RMP may be able to tell alternative treatments to the AMD maker's illness. Now, the Chinese medicine profession may not be at an appropriate position to do that. Now, in the setting of the AMD, some instructions against life-sustaining treatments may have to do with Chinese medicine practitioners as well. For example, CPRs or other resuscitation procedures which can be performed by Chinese medicine practitioners. So they also have a role to play. Reverend Kuhn, thank you. I support the bill. I also have a heart issue. Now, before the passing of my godfather, there was such an issue about whether CPR should be performed on him. But I ran into some difficulties with his families. My godfather was in a very advanced age, but I think his family had much difficulties accepting his wish. I think it should be done in a similar way with a will. That is, a person should be given the liberty to make a decision on matters after his passage. I think we must respect the patient's will. That person must have gone through a very vigorous thinking process before making a decision. But of course, the RMP has the responsibility to remind the patient of his or her choice. But we have to trust the doctors on this. Now, on easy revoking, it may be a safeguard, but I have a contrary view. If we are making the making of an AMD difficult, we have to do the same for revocation. Now, let me give you a scenario. For some wealthy families, they would try their best to sustain the life of a family member because on the passage of the family member, there are lots of matters to sort out. For example, power of attorney and will and so on. So before those things are sorted out, they would try to keep the person alive so that they can make all the arrangements in advance. So as long as the person has made a decision, if a family member claims that the person has whispered a view to a decision to the contrary to him and then told the same to the doctor, well, that would be rather doubtful. At the heat of the moment, because of the emotions and other matters, the family members may act against the will of the patient. Some family members would ask the doctors to give the dying patients a adrenaline boost or isotrope to keep the patients alive. So I think the revocation has to be made difficult as well. Under Secretary, I thank Reverend Kuhn for sharing your personal trauma, and I think this is something that we want to avoid. That's why we want to put the AMD into a legislative framework. There has been a lot of discussion on whether we are making revocation too easy. Still, we have to make sure that the patient is still mentally capable of making a decision. Concerning the scenario you mentioned, where the patient is mentally incapacitated, clinical judgment has to be made. That is based on the communication with the patients beforehand, whether there were signs that the patient wanted to revoke the instruction. If the medical carers are convinced that the patients were adamant as to the carrying out of the instruction, then acting on their professional judgments, they would judge that the revocation is not valid. Same goes for the contrary. And of course, we will educate the public on the most ideal way to revoke the AMD. It is best to be done in writing rather than making an oral revocation. It is only applicable on situation where the patient is dying and is unable to write things down. We will tell the patients that the best way to revoke the AMD is doing it in written forms. This would serve to prevent any conflict. Now, sometimes family members may be returning from overseas and they may claim that the AMD has been revoked. So I think the medical carers have a role to play. Now, I believe if I am the treatment provider, I will not take my chances. I will give you a CPR anyway. Well, I think that is quite counterintuitive. If anyone told me that, I would sustain the life of the patient no matter what, because of my conscience or because on the request of family members. Maybe I can invite Dr. Doris Jia to share her clinical experience. Thank you. Cautious making and easy revoking, this is not just a principle applicable to the making of an AMD. For example, I have quite a lot of end-of-life patients with renal failure under my care. I explained when they told us that of the decision of not to receive renal dialysis anymore, we would explain to them that they could revoke their decision. We will not let them make a decision just on a whim. We will tell the patients that this is not a done deal. They can change their mind at any time. Among the hundreds of patients I have taken care of, only 3 to 4 have changed their mind. But there are also patients who would ask us whether they could change their mind and whether the doctors would be willing to discuss this with them. They were reassured that we would help them whatever decision they make. We have seen families with only 2 elderly family members. So we can only rely on the elderly spouse of the patient. Concerning the will of the patient, there are no other family members to rely on. We have to strike a balance between the will of the patient and the dilemma faced by the family. We do not rule out that we may run into the scenario mentioned by Reverend Kuhn. At the very last moments, at the final moments, the doctors do have the power to make a decision whether to perform CPR. So a CPR may result in ribs fracture, or it may be pointless to do so. So for the best interest of the patients, the doctor may decide not to perform a CPR. But if the doctor decides that it would be in the best interest of the patients to perform a CPR anyway, the doctor does not have to bear legal responsibility. Concerning the emotional roller coaster experienced by the family members, well, we have seen a lot of cases that freshly returned family members have difficulties accepting the situation. So we will not judge them. We will show empathy to them. So we rely on the clinical medical carers to act on their best judgment. But I thank Reverend Kuhn for his sharing. Thank you, Mr. Lee Zhenkern. Thank you, Chair. This bill is painful, but we have to face it head on because life and death is a serious matter. On cautious making and easy revoking, I thank Reverend Kuhn for his sharing. First, we have to consider the maker of the AMD. A person may be told that he has a terminal disease, or with the advancements of medical treatment, stage 3 or stage 4 cancer patients may be treatable, and then they may wish to revoke their AMD. They may have the worry that by making an AMD, their treatment would be delayed and they would not be prioritized in being given treatment. So you have to tell people clearly that this will not be the case. Second, I am concerned about rescuers. Now in the paper, item 22, or paragraph 22, if a console operators receive a call for help and then they give a post-dispatch advice that the caller should not perform CPR on the person in arrest because of the presence of a DNA CPR order, then it may give the perception that the console operators are asking the callers to let the patients die. The communication between the caller and the console operators are private, so we don't know all the details. So how can we enhance the drafting of the bill to give a better perception to the public, and also the witnesses as well? How can we resolve all these problems?
Undersecretary. Thank you. Timing matters in the making of an AMD. The bill doesn't specify that. Based on current practice, we see that, say, for a cancer patient, when the patient realizes they have cancer, the healthcare workers do their best to try to treat the patient. But when we talk about AMDs, we are talking about in the end stage, and that's when the conversation starts on AMDs. Still, the bill doesn't specify when you can put the AMD in place. Let's look at our model form. Only under certain conditions, the AMD can kicks in. It has to be the end stage or something irreversible has occurred. So the AMD is only about refusing certain specified treatments, and they have nothing to do with the other treatment. So we will also make this point clear in our publicity to avoid misunderstanding among the public. Now, the member also brought up a point about DNA CPR orders. When someone sees a person pass out on the street, no, they don't have a responsibility to search for the order. The bill offers safeguards. The rescuer has no responsibility to search for an order. As long as the rescuer honestly believes they have to save this person, then they're fine. But what if the person involved whispers to the rescuer's ear that they don't need CPR? At that point, as long as the rescuer honestly doubts the word from the person who is passing out, then this rescuer is fine. Ms. Connie Lam. Thank you. I commend this bill. Dr. Tick and I are both in the social welfare sector. We are involved in end-of-life care, and also we serve seniors. Many people do need AMDs. There's a lack of awareness among seniors and their family members of AMDs. I've been talking about the 3 instruments of peace. I've been talking about AMDs for many years. I fully support this bill. And as other members said, let's hear from different stakeholders. We should hear from the social welfare, healthcare, education sectors. There are also self-help groups, community groups. Can we have a public hearing, or can we invite written submissions? Can we get the Secretariat to help us invite submissions, invite views from stakeholders? Just then, Dr. Doris Tse made a point, and she made a good point. AMDs are about respecting patients' wishes. And we should also respect the right of a patient to change their mind. This is something borne out by our experience. There are seniors living alone. Their children have moved out. I'm not talking about double-ton senior households. I'm talking about seniors whose family members have emigrated. The senior has many health conditions. One of them may be dementia. Dementia does not lead to instant death. And the people may suffer from the triple H, dementia, among other health conditions. The senior may have lost their mental capacity, but they have yet to sign an AMD. The family members have already immigrated, and all of a sudden, these family members come back to Hong Kong. They're all emotional. They're struggling. Should we save this senior? And that's something we should think about. Just then, Dr. Tick said only 5,000 or so have signed AMDs. That's a small number. I've been a social worker for more than 10 years. I'm slightly skeptical. I'm a bit doubtful. How can we tell the public that there is a need for AMDs instead of making other people do the job of explaining the need for AMDs? Let's look at the US example. The US has an act on patient autonomy. This act is there to give patients the right to refuse treatment. There are cases that we should learn from and look at from the US, Japan, or Europe, or even our own country. Undersecretary. Thank you. Life and death education is crucial, but that it has received little attention from the community. I hope that this bill can draw greater attention to life and death education. As Mr. Eddie Lee will know, we have consulted different stakeholders. We have been discussing life and death education. We've seen changes in the community. In 2004, there was a public consultation held by the Law Reform Commission. In recent years, we've seen growing acceptance of AMDs in the community, and they would like to see a formal channel to make AMDs. That's why we think the moment is ripe to go ahead with the bill on the AMD. Now, on seniors whose family members have left, empty nest. The seniors' children have left. The children have emigrated. We encourage these seniors to talk to their children because we want the family to agree on what to do. As Dr. Doris Tse said, we would like to encourage family participation in the process. Talking to family members overseas is just a call away. The family members need to be aware of the patient's wishes. In designing this bill, we have looked at the experience of other places. Some places offer very stringent rules, such that making an AMD is hard. Revoking is also hard in some jurisdictions. So we decide to come up with the principle of easy, or rather cautious making and easy revoking. Now, Mr. Eddie Lee can tell us more about the other points. Back in 2004, the Law Reform Commission held a public consultation, and in 2009, another consultation. 2019, yet another consultation. At the last term of the Legislative Council, we held meetings on this topic too. In December 2019, we invited deputations to come here. 18 deputations joined us. We had healthcare professionals, doctors, nurses. Social welfare sectors were also there. there were at least 10 publicity sessions. We forged a consensus, and then we have come to where we are. It is up to this Bills Committee to decide whether to hold further public hearings, but I just want to give you some context. Next, Ms. Carmen Khan. Madam Chair, I support this bill. The policy goal is clear. This is to ensure quality, comprehensive end-of-life care for patients and their family members and to meet their needs. I thank the Undersecretary and her team for proposing this bill. We are simply codifying what is already available at common law. There are legal ambiguities, and that's what makes legislation so important. Making, revoking, execution. This bill will provide an entire legal framework for all these steps to happen. We would also like the community to talk about death, life and death. So this bill is also an opportunity for education, for a community dialogue on this. The Undersecretary told us about 18 months in transitional period. So we should discuss when people should make an AMD and also when the AMD kicks in. That is when the maker is no longer mentally capable. There's a model form in the bill. It contains different scenarios. Witnesses are needed for the making of AMDs. The conditions have to be met in the model form before the AMD kicks in. So we have come to a terminal stage and an irreversible development has taken place. Here, professional judgments are required. The publicity should let the public know when certain things kick in, when an AMD should be made, when an AMD takes effect. That can reassure the makers. This bill should be about helping people make informed decisions. We should let people know how they can make an informed decision about AMDs and that the patient's wishes are respected by their family members, so that we can avoid family pushback when the patient wants the AMD. So measuring the success of this bill will require us to look beyond just numbers. More isn't necessarily better. We would like to see a more proactive mindset on discussing life and death. After a discussion, people may decide against making an AMD. That's also a sign that the bill works. So the point is we shouldn't just look at numbers in measuring the success of this bill after it is enacted. But of course, we may see more AMDs after the bill is passed, and that's also positive. Now, to make an AMD valid, you need witnesses. One has to be an RMP, and the other witness has to be someone without beneficial interest in the patient's estate. Now, when you look at the will, there's a beneficiary. The person may not want other family members to know who the beneficiaries of a will are. So here, the person, the maker of an AMD, has to be careful in picking who can be a witness. Only a disinterested party can be a witness. So there is a moral risk we have to look out for. So when we require the witnesses, we need to let people know what options there are in picking witnesses. Or say someone has made a will and then there's a change in the beneficiary, and these are operational details because the beneficiary cannot be a witness of the AND. Ms. Khan, can you give time for the Undersecretary to give a response about the witnesses? You can ask follow-up questions later. Can you let the Undersecretary respond to your questions first, and so that other members can get to speak?
Undersecretary. Thank you, Chair, and thank you, Ms. Khan. Ms. Khan is right. We want to start a dialogue in society about the issue of life and death. We have seen too many cases where there has not been such a dialogue in the family. As a result, at the final moments, the wish of the patient was not respected. We agree that we should not judge the success of the bill by the number of AMDs made. Concerning the matter of witness, according to our clinical experience, most of the witnesses would be nurses or doctors or the healthcare team. So we will educate and train our staff on the definition of disinterested party. I think we have to strike a balance. We have to let the family members know that they have to respect the decision of the family members, and also when the will or when the AMD is made, the family members should be present to avoid dispute. Mr. Dennis Leung, Chair, I support the bill. We want to respect the decision and preference of patients. There is a case where a little girl was admitted into the ICU because of myocarditis. The situation was acute. Multiple rounds of inostrop were administered to the girl. So there was a discussion whether the girl's life should be sustained in case of another cardiac arrest. I was also involved in the discussion. So I want to know about the current practice. The bill is straightforward. When the patient is still mentally capable of deciding, an AMD would be made with the witness of a doctor, and then a DNA CPR order would also be made under the assistance of the doctor. Family members are not eligible as witnesses to these documents or instruments. Well, when the situation is acute, in the absence of an AMD or a DNA CPR order, there were cases where interested parties were involved in decision making. So how can we send a clear message to the public about these? I think this is something that we have to ponder upon. Second, with the advent of the internet, everyone has a mobile phone, and we can make video recordings whenever we want. Well, if a doctor has been filmed not performing CPR on a patient, he may be wrongly accused because the patient might have an AMD. On the other hand, doctors may be criticized online that they refuse to perform CPR on a patient with an AMD or a DNA CPR. That is extremely unfair to the treatment providers and rescuers. So how can we immediately clarify things up so that the rescuers would not be wrongly accused? It may be a stain on the treatment providers because the video will be on the internet forever. As long as the patient is of age and is capable of making a decision, an AMD can be made. Should there be more constraints or requirements? I think you have to think about that. There should be a procedural manual or guidelines in the making of an AMD. More instructions should be given to doctors and nurses on the situations where a patient should be advised to enter into an AMD. Thank you. So these are two real scenarios mentioned by Mr. Leung. Thank you very much. The first scenario mentioned by Mr. Dennis Leung, the acute myocarditis, well, it may pertain to the DNA CPR order more. Two situations may warrant the entering into of a DNA CPR. The first one is that there is an AMD. The second one is to make a DNA CPR order without an AMD. Two RMPs are required, and only doctors are qualified to do so. One of them must be a specialist. The doctors must have a consensus on the diagnosis and that further life-sustaining treatment would not be in the best interest of the patient. Before entering into a DNA CPR order, families' wishes must be consulted. This is about the trust between the doctor and the patient's family. The doctors must explain to the family members that they believe that further life-sustaining treatments would not be in the best interest of the patient. Then the order can be made with the consent of the family members. And no CPR would be performed on patients when the situation takes a turn for the worst. On the scenario where video recordings are made on CPR not performed, of course, we have to educate the public to prevent the occurrence of these situations. We have to educate the public what DNA CPR and AMD are. Not performing CPR on a patient with a DNA CPR order or an AMD is how we respect the patients. We have to educate the public on this. Second, for false reports or misinformation online, the government would clarify these promptly. We will set aside 18 months for the provisions to kick in after the passage of the bill because we want to educate the public on what DNA CPR orders and AMDs are. We will definitely put efforts in these. Next, Dr. David Lam. Thank you, Chair. I support the bill. Having read the bill, I understand the purpose of the bill. It is to respect the decision made by terminally ill terminally ill patients or patients in end-of-life stages. But this is not clearly written into the bill. I believe there may be some rare cases where decisions might be made prematurely and that AMDs and DNA CPR orders are made prematurely. We all understand that we think differently as the final moments. Problems may arise. For example, the patients may want to rescind the AMD but cannot. So maybe we have to write it clearly into the bill that this is only limited to terminally ill patients. More than one member have mentioned about the roles of family members as witnesses. We understand the possible complications with family members standing witness to an AMD. But if I were the patients in question, I would love to have my family members to support my decision for adding their signature to the AMD. We can simply add the signature of the family member to show support for the patients with no legal effect. On the question of form, I think the form is unduly complicated. And I don't really understand the wordings used in the Chinese version. Now, the doctors have to prove that he or she is of age, or I would be surprised if a doctor is under the age of 18. And also, there is a line stating that I have an illness specified in Schedule 6, and then you have to read Schedule 6. It is so convoluted. It would be very complicated for a layperson. And the directives are only to be found at the end of the form. You have to make sure that the directives are easily located. Otherwise, it would defeat the purpose. So the second witness, concerning the witnesses to the AMD, they must be of age and they can't have any beneficiary interest with the patient. I agree that, but what about the presentation of the identification documents? It may be too much to ask. So in the end, it may be doctors and nurses who stand witness to the AMD. The doctors can give their registration number, but what about the nurse? Do they have to present their identity cards as well? So please reconsider the requirements of presenting an identification documents. So these may be the nitty-gritties of the deal, but please enhance them. Under Secretary, thank you, Chair, and thank you, Dr. Lam. True. In the bill, we haven't specified the illnesses under which a patient should make an AMD, but we did require doctors to explain the effects of an AMD and the nature of an AMD. We are not setting out clearly that only terminally ill patients are allowed to make an AMD because we trust doctors to explain the nature and effect of an AMD and the instructions on the maker. So the doctors are the gatekeeper. So let's say if I signed an AMD when I was young and then 30 years after, I forgot the existence of the AMD. It's fine. You can present a copy to the doctor. If you do not do so, the AMD will not be valid. Concerning immediate family member's signature on the AMD, whether a signature would signify support for the decision. Well, I believe that the family members would be present all along in this discussion. This kind of support would be more meaningful. I was also involved in this process. The best support a family member can give to the patient would be to consult the doctor together with the patient. Concerning Dr. Lam's suggestion on enhancing the form, we will review the form after the meeting. We will only accept one kind of model form. We have to make sure that all organizations understand what a model form of AMD is. We will try to improve the design of these forms. On ID, this is a necessary requirement because we have to make sure that we have to be sure about the identity of the witness.
下一輪
One follow-up question. You have to wait for the next round because other members are waiting to speak. Next, Ms. Eunice Yong. Thank you. AMDs already exist at common law. For those with the mental capacity, they can express in writing their wishes about treatment. They can refuse life-sustaining treatment. After this bill is passed, the matter goes to the court. Then Hong Kong's laws and common law will be applied. So we need to make this clear. We're sticking to the common law. We are just putting in place a piece of legislation that goes along with the common law. Now, in 2019, there was a consultation followed by a previous recommendation. In 2019, there was widespread support for legislation. I looked up the judiciary's website. I haven't found any legal dispute turning on AMDs. The bill here is about protecting healthcare professionals when they execute AMDs. We haven't had legal disputes over AMDs. Can the government tell us about the legal risks? Were there disputes where healthcare professionals were caught up and that entailed this bill? We already have safeguards with the current system. Why have this bill? The public would like to know. Consultations aside, as Dr. David Lam was saying, AMDs are not just for dying patients. For someone 18 or above, they can make an AMD. So how much work has been done in terms of public awareness and about awareness among healthcare professionals, Undersecretary? I cannot comment on the legal risks about the court cases, etc. For healthcare professionals, the way to minimize risk is to not recommend AMDs. And the current system has little to start a discussion about end-of-life care or AMDs. People don't make AMDs, they don't start talking about AMDs. At care homes, there are many seniors without AMDs because there is no safeguard, so people see no incentive to do the AMD. That's why this bill is necessary. Now, on the work we have done on AMDs. On end-of-life care and life and death education. The government, social welfare bodies, and schools have conducted life and death education. There's now more widespread discussions about life and death. The hospital authority has done more training. We have explained AMDs to healthcare professionals, and at HA we have advanced care planning. So even without an AMD in place, doctors talk to patients about this option. There's also more palliative care so that the public is better aware of the options when the end-of-life stage comes. The hospital authority also has publicity initiatives. At patients' resource centers, there is promotion. The Department of Health also conduct life and death education at care homes. The HA also works with care homes on this. We do advanced care planning with seniors. We talk to the seniors about this option of refusing treatment at a certain point. Over time, there is growing acceptance from the family members of care home residents. This is where we can do more. Now, on social welfare sectors, at hospices, there's also promotion, education, and end-of-life care. There's also medical social collaboration on this front at care homes. This is all promotion. Once this bill is passed, hospitals, healthcare professionals will be able to do better in promoting life and death education. Mr. Tang Fei, I'm a member of the Public Complaints Committee at the Hospital Authority. We haven't seen complaints about AMDs in the past. We don't have court cases, but there may be a rise in public complaints about AMDs if this bill is passed. Just then, the government mentioned life and death education at schools, but school education rarely gets into such detail. After all, we're talking about minors at schools. Primary and secondary school students may have little notion of death until someone in the family passes away. More teaching materials are needed for schools on life and death education. The school can only describe death in broad terms, and at some point, euthanasia may come up. Now, CB bracket 41129, paragraph 6 and 7. A member of the panel on health services asked the government to clarify the distinction between AMDs and euthanasia. The government explained that AMDs have nothing to do with euthanasia. Euthanasia is illegal in Hong Kong. So AMDs have nothing to do with euthanasia. But euthanasia can take a passive form. So here, the government needs to clarify things in a succinct way. This bill is called Advanced Decision on Life-Sustaining Treatment Bill. Life-sustaining is a broad concept. It covers cardiopulmonary resuscitation. It can also mean drips, oxygenation. people think of all kinds of those things, drips, oxygen masks, etc. The bill may cover just cardiopulmonary resuscitation. It doesn't cover other treatments. But those treatments are there. The bill is just about CPR. But the name of this bill sounds so broad that the public may get the impression that they can just refuse treatment when they are terminally ill. They can refuse blood transfusion and drips and oxygenation. So greater efforts at clarification are needed. Otherwise, people will start talking about online that Hong Kong is starting passive euthanasia. This is about driving a cultural change, so we have to be cautious. Now, CPR. This is for the terminally ill. When someone is in cardiac arrest, people can refuse CPR as long as they have filled out the forms. But what if you have a car crash? It's unlikely a victim will want to give up CPR because that victim cannot indicate a refusal of CPR. We have to be clear that the DNA CPR order can only apply to specific conditions and not due to something like an accident. This point needs to be clarified. We need to explain this clearly to the public. Now, Dr. David Lam made a good point. On the statutory form, there's liability involved. The AMD instructions are put at the end of the form. Can we put the legally substantial parts up front? We put the subject's information up front. We put the healthcare professionals' information at the back. When you retrieve this form, it's when something has gone wrong, the family members are distressed, the healthcare workers will have a hard time explaining the details. So can we make changes to the forms? Thank you. Undersecretary. We will look into ways to simplify the forms. Mr. Tang made a great point about, say, teaching materials for schools to promote life and death education. I want to clarify 2 points. First, life-sustaining treatment. This bill is not just about CPR, like chest compression. We have set out examples. Some want to refuse blood transfusion or drips. They are part of life-sustaining treatment. Now, for the AMD, 3 things need to be set out. First, the AMD kicks in when the maker is no longer mentally capable. When a car crash happens, it is not a specified condition in an AMD. So in that case, the AMD does not kick in. And when an AMD does kick in, it only applies to specified treatments such as chest compression in a CPR or drips or blood transfusion. They have to be set out expressly in the AMD. Indeed, so much needs to be done in public education. We will step up promotion when the bill is passed. We will tell people clearly what euthanasia is and what AMDs are.
Next member, Ms. Doreen Kong. Thank you, Chair. I support the bill in principle, but I have a question on its operation. Recently, my auntie passed away. when she was very sick. Well, I'm not her family member, but I was a very good friend to her. When she was very ill, she told me that she didn't want to be resuscitated. We understand this sort of thinking among elderly people. I was not a family member, so let's say if the bill is passed and an NMD was made by her, well, I would not know whether she had an AMD made. So if I'm just a visitor, how do I know if she had one? I understand the principle of easy, a cautious making and easy revoking. But what about an oral expression of wish? Would that count towards an AMD? There are two matters to consider. First, there will be an AMD in written form as well as in digital form. As long as there is one, we can look for it on the system that can be easily retrieved. And also, medical carers will ask the patient whether there is an AMD in place. Usually, an AMD would be made together with the help of healthcare professionals, so they would know. Friends of the patient may not know, but the medical team will know. If there is an oral expression that the patient doesn't want to be rescued, then it's better to have an in-depth discussion and then make a written AMD. For oral revocation, that is only applicable to the revocation of an AMD rather than an establishment of an AMD. So if a patient tells you that he or she doesn't want to be resuscitated, then you have to talk in length with the patient on his or her wish. Revocation is possible when a patient thinks that he or she now wants to be resuscitated when the situation takes a turn for the worse. That can be done verbally under the principle. Under Secretary, I think the idea of an AMD is very good. But I think public education is necessary. They have to understand that everything must be discussed together with the medical team. Otherwise, there may be confusion. When the bill is passed, I think you have to do a round of very thorough public education. Next, Ms. Lillian Kwok. Thank you. Let me state my position up front. I support the bill. I think Hong Kong has been moving too slowly. 20 years ago, when I was a social worker, I had a case with an AMD. The idea was quite foreign back then, but in recent years, it has received more attention. We have an aging population, and more families are facing end-of-life situations. Protection for medical carers and family members are necessary. I hope the bill will be beneficial for all parties. On its operation, over the past 20 years, the HA and NGOs have established their own AMD system. Some AMDs are just on a piece of paper with witness. Some might have been made under an oath administrator at the district office, and some under a lawyer. So you will allow AMDs in electronic form. So what will happen to these pre-existing AMDs? Maybe patients will need help renewing their AMDs and making AMDs new. So what if a patient takes out an old AMD which they made with the help of the district offices? Should we follow the instructions on these AMDs, or whether we should follow only instructions on AMDs made on the model form? I believe the bill will enhance the awareness on end-of-life care. Now, for palliative care, the demand outstrips supply a lot. So in terms of the capacity of our palliative services, we have to enhance it. Otherwise, the hardware and services cannot catch up on end-of-life care. No matter how much we talk about end-of-life care and dying in place, if our palliative hardware cannot catch up, it will be disappointing. Under Secretary, thank you. Concerning the forms to be accepted during the transitional period, I will defer to my team. On palliative care, over the past few years, the government has dedicated resources to increase manpower supply to our palliative care. We expect that after the passage of the bill, we will have to ramp up the relevant service capacity as well. Deputy Secretary. Chair, concerning the question raised by Ms. Kwok, that is a very pertinent question. For those with pre-existing DNA CPR orders, now usually they need to be renewed. The expiry period is 12 months. So upon the expiry of this batch of the DNA CPR orders, we will ask doctors to use the new statutory forms. The point is we will only allow one statutory format of DNA CPR orders in the future. Otherwise, it will be very confusing. On AMD, after the passage of the bill and after the provisions have kicked in, we will train the doctors. It will be easier because AMDs are mostly used in the hospital setting. So we will train hospital authority doctors on the new requirements. For pre-existing AMDs which meet all the requirements under the new bill, then we will treat them as valid. Thank you. That concludes the first round. I am the last member to speak. It is my time now. First, the policy intents of the bill, I support it. But I want to clarify something before going into the clauses. AMDs and DNA CPR orders. For DNA CPR orders, two doctors must stand witness. One must be a specialist. Now, for irreversible or untreatable illnesses, I've handled cases with such patients. For example, spinal cerebral atrophy. The patient's family has called an ambulance for the patient. DNA CPR orders were made. But you know, for patients with the disease, in the final stage, they can't even move their fingers, not to mention talking. So for these patients, how can they present a paper format DNA CPR order to the rescuers? How will these situations be dealt with after the passage of the bill? Let's say if I'm a friend to the patient's suffers from a suffocation during my visit, then what should I tell the rescuers? Of course, the rescuers would perform a CPR. So will these patients with irreversible disease be required to put the DNA CPR orders and carry them all the time? What if they do not have any motor capacity at all? How can they present the order to the rescuers? On the principle of cautious making and easy revoking, the patients might have given an instruction in oral terms when they are still conscious, but what if they have lost the capacity to do so? What if they want to revoke the order? Should we ask them to blink once or blink twice to express their preference? Thank you. Thank you, Chair. On your first question, if the patient is unable to present the AMD or the DNA CPR order because of immobility, then it would fall upon family members to present the order or the AMD to the rescuers or to the treatment providers. It may be problematic for singletons. If they have an AMD and they are hospitalized, they can't speak and they can't present their orders, what should we do? For these cases, we would advise doctors to make use of the future electronic registration system or the electronic storage system. We will include a prompt function within the system that whenever there is an AMD in place, the doctor would be prompted. Then it would free the patients from the responsibility to present the AMD. And as I said, the family members should also present the documents to the doctors. On the second case mentioned by the chair, that is a cautious making and easy revoking, we respect the decision of the patient, but he or she may not be able to give an express instruction. So that would be up to the interpretation of anyone beside the patient. But we allow revocation in writing, in oral form, or any indication made by the patient. So for example, nodding, shaking the head, or blinking. As long as the patient is able to indicate his or her wish, it can be revoked. Many members are concerned about the plight of carers. Many of their charges have irreversible or terminal diseases. So sometimes when we did a voluntary work, we want to provide some respite to the carers. And the carers wouldn't tell us about the existence of the AMD. They know the wish of their charge, but they might have forgotten to tell the same to the social worker or the volunteers, and then an accident may happen. You now rely on the presentation of a paper form, DNA CPR order. So can we design a sort of badge for the patient? In other countries, they have a card or a badge showing the existence of the DNA CPR order. You are still relying on a paper form order, so should I present the order to anyone who visits my charge? These scenarios are real.
I get your point. AMDs are better. Now, but for DNA CPR orders, we need the paper-based orders. We don't do electronic forms for these orders because the decision about CPR is a split-second decision. The patient needs to have this order at hand, nearby at their fingertips. So when you do the public education, please make this point clear about the paper-based forms. Now we are done with the first round. We will do a second round. We have up to 12:45, so I'll give 4 minutes to each member. Questions and answers inclusive. Ms. Connie Lam, speaking for the second round. Undersecretary, I want to follow up on some points from my first round. Just then, Mr. Eddie Lee told us in 2019, the Food and Health Bureau consulted people in districts. What were the findings? Can the Bureau give us a paper about the consultation back then? And can we also invite other views on this matter? Now, for AMDs and DNA CPR orders, there's talk about using technology and using I Am Smart as a great app. We talked about HA-Go and eHealth yesterday. Can we link up HA-Go and eHealth in the future? It's such a hassle as things are now. I want to keep track of my own appointments and those of my family members. But then HA-Go and I Am Smart, or rather eHealth, are in their respective silos. Can we link up the two apps? So once you link up the systems and we upload the paper, people can see the documents. Say, for me, I want to check my follow-up appointments. I can also check the records of people under my care. So say if we can have DNA CPR orders and AMDs on eHealth, on HA-Go, can this be done? On paper forms, we need paper forms. Even if we go electronic, we need paper forms. The reason has been explained by other members. We never know when our last moment is. A complication can happen all of a sudden. So that's my point. After the law takes effect, there are paramedical staff members, allied health professionals. Many people are involved. They are medical carers. Of course, they want to save lives. So once this bill is passed, for different healthcare settings, the healthcare professionals stick to their own professional ethics. But let's be mindful that family members may want to see their family members safe, the patient saved. So we should respect the wishes of these family members too. Undersecretary. Now on HA-Go and eHealth, we are working on access rights and linking up the apps. Once we have a progress, we will let members know. Over to Mr. Eddie Lee. In 2019, we had a deputation hearing. At the meeting, there was a meeting of the panel on health services on December 13, 2019. Member can refer to the minutes of that meeting. So that's the meeting on the 13th of December 2019. Now we had publicity on AMDs. There were deputation hearings. Can the government give us a paper? Or rather, we can invite written submissions on this proposal, and then we can pass on whatever we receive to the government. Any views from members about this? So we invite public submissions in writing because there were public consultations at district level. The government also met with professional bodies. Now, members can refer to the gist of the hearing from the meeting in 2019. So let's also invite written submissions this time, so then we can put together the submissions and then we pass on the message to the government. Because when you do a public hearing, the date may not work for some stakeholders. So we can talk to the Secretariat about inviting written submissions. And if members are all good with this, let's do this. Now, let me first extend the meeting by 15 minutes so that the remaining 3 members can finish their questions and answers. Ms. Kamen Khan, thank you. We have spent 2 hours on the policy matters. This committee and the public may have all kinds of questions about the proposal. Can I ask the government to prepare a PowerPoint setting out the legislative intent, the reasons for the bill, and also the differences between the AMDs and DNA CPLs. So it's a bit like an all you need to know about the bill, everything at a glance. So AMDs are decisions made in advance to not receive life-sustaining treatment. And there are many pages to this bill, and there are many schedules. Now you need some conditions to apply before the AMD kicks in, someone in a vegetative state, end-stage diseases, irreversible diseases. The patient can choose not to receive specific treatment. The patient cannot turn down basic and palliative care. The patient can choose to refuse some treatment. I want the public to get a better sense of what AMDs are. And DNA CPR's orders are in order. It's not an expression of wishes. That's why we require a paper form for DNA CPR orders. A paper form is needed because rescuers are involved and the government is exploring electronic AMDs. So the government needs to set out why we can have electronic AMDs but not electronic DNA CPR orders. I spent time reading the bill. There are key points that should be set out in my PowerPoint. Now, safekeeping is a point in the bill. We cannot make electronic AMDs today. What you can do today is to make an AMD, scan it, digitize it, and then put it online. AMDs are among the 3 instruments of peace. We asked for a centralized electronic platform. Still, people cannot make an electronic AMD direct. what they can do is to scan and digitize a paper-based AMD. The bill also says that a certified true copy of an AMD kept by a family member is also valid. Paragraph 11 covers this, and then paragraph 12 is the government's plans about electronic AMDs in the future. But going electronic does not apply to DNA CPR orders. The reason is that the order may need to be invoked in a setting outside hospitals. A rescuer needs to see the paper copy of the order. So the government needs to explain these points. Let's explain. For DNA CPR orders, there were statutory forms. But then for AMDs, there's a model form. And the model form is only for reference, which is different from the statutory form for the DNA CPR orders. So maybe we can do an FAQ. So that's a comment from Ms. Khan for the government to consider. Let's find a way to better inform the public about this bill. Next, Mr. Michael Lee. Thank you. I have a similar idea in mind. Someone signs an AMD. How can this maker let their family members know? So that, say, when a rescuer comes along, the rescuer is aware of the AMD. The maker has to let the healthcare professionals know about the AMD. So the communication matters at the hospital. Mr. Tang Fei said, say you have a car crash. Should we save this patient? Better communication is needed so that the medical carer can decide whether to save this person. After all, lives are at stake. My third question went unanswered by the government. It has to do with witnesses. The witness has to be a disinterested party. Does that mean anyone can do? Say a fellow patient in the hospital. Can a fellow patient in the hospital be a witness to an AMD of another patient? Or say a fellow patient eventually becomes a family member or spouse or something. What happens then? So can the government tell us more about the witnesses? So that's a scenario question for the government. Mr. Eddie Lee, please. First, this witness has to be an adult, and second, this has to be a disinterested person. Then this means the witness cannot have any beneficiary interest in the maker's estate. This witness has to be a disinterested party to the best of the witness's knowledge. So this is about to the best of the witness's knowledge. And that's good enough. Deputy Secretary, Mr. Lee's point is about the change in the status of the witness. At the point of the witnessing, the witness has no ties with the maker. But what if there's a subsequent change in the relationship between the witness and the maker? Mr. Lee, the principle is to respect the patient's wishes. So the maker has the wish, the doctor has explained how it works, and then the witness, to the best of the witness's knowledge, is a disinterested person. So in this case, the AMD is valid. So if there are subsequent challenges, the maker can explain that at the time of the making of the AMD, the witness is not aware at the point of making that the witness is a interested party. So if the question is, if this witness turns out later becomes a spouse of the maker, does another witness have to be involved? Now, it's different if the witness knows they are going to get married with the patient soon. But this is not spelled out in the bill. This is about to the best of the witness's knowledge.
多謝主席。
Dr. David Lam. Thank you, Chair. My question is on unconscious minors or children under the DNA CPR order. A co-signatory is required. The requirements are laid down clearly. What if the person is a person without any family members in Hong Kong, for example, an elderly singleton without a co-signatory? Will the DNA CPR order still carry effect? Second, about AMDs. Instructions may include refusal of CPR. AMD has no expiry period, expiry date. So on the basis of an AMD, a DNA CPR order can be made. But that order has an expiry date. So when a person became incapacitated, the AMD is there, but the DNA CPR order has gone missing. Should CPR be performed on him? For AMD, if no other witnesses are available, doctors and nurses stand witness to the making of an AMD. Will you allow the doctors and nurses to use their registration number as proof of identification? Deputy Secretary, according to the bill, the guardian to a person who is mentally incapacitated can be the co-signatory. Concerning the expiry of validity period of an AMD or DNA CPR order, it depends on the medical situation of the patient, on how long a DNA CPR order will be valid for. But there are guidelines for doctors and nurses. Of course, it won't be indefinite. What if the DNA CPR order has gone missing? Or misplaced? If that's the case, then a temporary form will have to be issued to the patient. So maybe the DNA CPR order has gone expired, so it has been thrown away, or it has been misplaced. So what happens? Well, we will fall back on the AMD if certain conditions are met. Well, the misplacement of a DNA CPR order is one such condition. So what will happen? If it is in a hospital setting, AMD is effective, then the instruction will be effective. So what if the DNA CPR order is gone? Do we need a new one? As long as there is a clear instruction on the AMD that the patients refuse CPR or life-sustaining treatment, then the AMD is valid, so there will be no CPR performed on the patient. What if the ambulance man doesn't see the DNA CPR order? Will CPR be performed? Well, ambulance man need to see a DNA CPR order in order not to perform CPR on the patient. So can doctors and nurses use their registration number as identification of identity? Well, we will review the requirement. What about co-signatory? There are cases where there is simply no one to co-sign the order, and you can't find a guardian immediately. So what should we do? Can the DOJ help? There is a requirement concerning co-signatory. That when the person in question has become mentally incapable, or if it is impossible to find a co-signatory, well, let's refer to the blue bill, C3328. I know we are not at the clause-by-clause stage yet, but please refer to the bill. So depending on the relationship between the person and the patient, the doctor and the patient, or the frequency of contact or level of perceived closeness, the doctor can stand witness to the AMD. Well, what if there is simply no such a person? Will you apply for guardianship for the patients immediately? Dr. Jie, please switch on Dr. Jie's microphone. I think at least the patients would have a carer. So if there is sufficient closeness between the patients and the carer, then the carer will fall into the category in the bill, and the carer can be the co-signatory. Concerning the question raised by Dr. David Lam on whether the nurse has to present the ID card, well, according to the form, other identification documents are also valid. So I think the registration number of an enrolled nurse will do. Next, Ms. Carmen Kan. 3 minutes. This is the second follow-up question. My question is on the principle of cautious making and easy revoking. So I think in the upcoming PowerPoints, the administration can explain to us more clearly about the revocation of AMD. It carries legal effect, and in paragraph 10, the paper says that on revoking the AMD, the maker must be mentally capable. And whether a patient is mentally capable needs to be assessed by a professional. It should also be written into the bill. Now, Clause 10 premises upon a assumption. Unless proven contrary, a decision made to revoke the AMD would premise on the assumption that the maker is mentally capable. So I think that's a safeguard on easy revoking. So we asked questions whether the maker simply needs to nod his head in front of a witness to revoke the AMD. So paragraph 10 says that as long as there are more than one witness, that will work. And through the mouth of the witness can tell the HA that the patient decided to receive life-sustaining treatment. So I think the administration is erring on the safe side. So is that your thinking on easy revoking? We rather save the patient against his or her wish rather than letting the patient die when the patient doesn't want to. Now, maybe the decision was made when the patient was mentally capable, but like the doctor said, it is not a done deal. We want to provide a way out for the patient. And you make the requirements quite lenient. You will accept the statement of just one witness. Yes, you are right. We rather err on the safe side. If we do not perform a CPR, then the patient will not have a chance to tell what he or she really wants. So he wants to give the patient this chance to choose what he or she really wants. Ms. Connie Lam, thank you. 2 weeks ago, we had a discussion on this as the subcommittee. So I would like to give you my take on this. Now about this bill, it involves more than AMDs and the NACPR orders. We need to review a lot of legislation in relation to end-of-life care. Dr. Jie said that most patients would have carers. Well, that's not the reality. I know a lot of moderate to severely disabled elderly patients. They need the director of social welfare to be their guardians. They have no carers. So do we need to review this requirement? Second, I know this is not part of the bill, but how do we define MIP or mentally incapacity? How do we determine that at a stage the patient is still capable of making decisions? We need the elderly people to know that they can still make a decision. So we have to ask them to sign the form when they are still capable. So when they become mentally incapacitated, suddenly there would be distant family members popping up, staking a claim to the estate. So I think the issue is a very broad one. Please consider reviewing other legislations as well. Undersecretary. I think it is impossible to address all the issues you mentioned with just one bill. Concerning end-of-life care and AMDs, the discussion has been ongoing since 2004. We want to take this step first and then consider reviewing other legislation. We don't want this bill to be encumbered by other legislation because it is urgent. But I understand the concern of the member. We will have more discussion on this. Undersecretary, I really hope you can review the matter of guardianship. How do you define a guardian to people with cognitive impairments? Many of them have the social welfare department's head as their guardian. So please give us more details and have a discussion on this. Thank you. I think we have all spoken on the policy matters of the bill. For the other areas of the bill, we will save it for the next meeting. The bill is very thick and there are much to discuss. So please save your questions till next time. Item 3, AOB. We don't have AOB. Meeting is adjourned. Thank you.